Modes of dissolution of partnership firm. In the previous video we studied that what is a dissolution of partnership firm. Now we will study modes, that why there is a need of dissolution of partnership firm, what are the circumstances in which the dissolution occurs. So first is by mutual agreement. Section 40 of Partnership Act says, by mutual agreement a partnership firm may be dissolved when all the partners agree for its dissolution. Second comes compulsory dissolution. Section 41. Now, what are the conditions under which the compulsory dissolution has to take place? Solvency. When all but one partner of the firm becomes insolvent. Then the second one is when the business becomes unlawful. Business of the firm becomes unlawful, which is not according to the law. This is the compulsory dissolution. Third comes on happening of an event. Section 42. A firm may be dissolved on the happening of any one of the following incidents: either the insolvency of the partner, on the fulfillment of the object for which the firm was formed, on the expiry of the period for which the firm was formed. So anything can happen. On happening of such events, the dissolution occurs. By notice. Section 43. Now, when the duration of the partnership firm is not fixed and it is at will, any partner by giving notice to other partners can dissolve the firm. So by giving notice, one partner can give notice to the other partners and there can be a dissolution of partnership firm. By order of the court. Section 44. Now the court may, on an application by the partner, order the dissolution of the firm. Now what are the circumstances under which this happens? See, first can be the partner becomes unsound mind. The partner has become of unsound mind. When a partner other than the partner filing a suit has become permanently incapable of performing his duties as a partner. Incapable. When a partner other than the partner filing a suit is guilty of misconduct that may harm the partnership. Misconduct. Then when a partner other than the partner filing a suit has transferred the whole of his interest in the firm to the third party. Transfer of interest to third party. When the court is satisfied that the firm cannot be carried and except at a loss. Continuous losses are being occurred by the firm. When the court is satisfied that the dissolution is just and equitable due to some reason. Means court may find that they need a dissolution, right? So this is the various modes or circumstances under which the dissolution takes place. In the coming video, we'll be studying more about the dissolution. Till then, do subscribe our channel and please download our Scholars Learning app.